Hello friends, this is Dr. Ritu Chhabra, Assistant Professor, ICFAI Law School, Hyderabad. Today's topic which I am going to discuss is admissibility of e-evidence in the court of law. So first of all, what is evidence? Actually, I will give you an example of this. Suppose a crime is committed somewhere and the FIR is lodged. Now the investigating officer, his duty is, he will just investigate the matter, and during investigation he just find some evidences, and on the behalf of those evidences he file this charge sheet in the court of law, and the court start proceedings after this. Means the evidences produced by the investigating officer as well as both of the parties. The hearings begins, and after that the court pronounce the judgment on behalf of the evidences which were produced by the parties as well as the investigating officer. So we can see that the role of evidences are very important while pronouncing a judgment by the court. In the same manner, if I will ask about the e-evidence, so we know that we are living in this digital era and we are living in digital India as well as globally. Everyone is using cyberspace. That's why the crime related to cyberspace is increasing day by day. So what are these type of crimes? Pornography, obscenity, banking, online banking theft, frauds, and some trade related issues we are facing. So because we know that this cyberspace is proper, means like anybody can commit a crime from any location, from any remote location. So it is really difficult for the investigating officers to find the criminal. And suppose one location is found by the investigating officer, then how the evidences can be collected, how they will be analyzed, how they will produced before the court. This is the main issue before the investigating officers, the experts as well as the court, that whatever the e-evidences are produced before the court, this is admissible or not. So these are some aspects we will discuss today along with the laws and provisions and as well as some landmark judgment. So I have divided this session in three particular parts. One is I will discuss evidences. Second part, I will discuss the admissibility of e-evidences in the court of law. And third is some landmark judgment we will discuss. So first of all, evidence. According to Section 3 of Evidence Act 1872, evidence means and includes all such statements which the court allows or needs to be presented before it by the witness in connection to matters of fact under inquiry. So these statements are termed as oral evidences, while all such documents include any electronic record presented before the court of inspection. These documents are termed as documentary evidence. So electronic record, what is it? Electronic record is data, record or data generated, image or sound stored, received or sent in an electronic form or microfilm or computer generated microfiche. It means any mail, any message you received or you sent, or any other document, that is electronic record. And this electronic record term is inserted in this Evidence Act by the amendment and by enacting the IT Act 2000. So these evidences can be categorized into two parts. First is oral evidence. Oral evidence is simple, that one person is appearing before the court and he is recording his judgment. So that is oral evidence. But what is documentary evidence? Documentary evidence is including the electronic records as per the amendment. So any documents, like if suppose there is an email and it is showing some criminal content. So this particular email can be produced before the court as a documentary evidence in the hard copy. So this is what the oral and documentary evidence. What is primary evidence and what is secondary evidence? The oral evidences are these are primary evidences. So, but now in relation to the evidences, how primary evidences. So, suppose if I am standing on my roof and two people are fighting before me on the road, and suddenly Mr. A and Mr. B, they are fighting, and Mr. A is picking up a stone and he hit the stone on the head of Mr. B. At the same time, Mr. B did. So, and out of curiosity, what I did, I just recorded all the incident in my mobile phone. While investigating officer approached me and he asked me to give my mobile device to him as an evidence. So, when this evidence and I produce before the court and I just give the statement along with the original device in which I have recorded the incident. So, this is primary evidence. While secondary evidence is that the CCTV camera is installed in my premises and the same incident is happening before my house, and each and everything is recorded in CCTV camera. But now the CCTV camera cannot be produced before the court. So, while investigating, when police officer approach me, I will give him that particular footage to produce before the court. So, this is the secondary evidence. But is it admissible in the court of law? How will be the authenticity of this CCTV footage will be authenticated, or it can be recognized or analyzed? So, it is a recognized principle of law, first of all, that if primary evidence is available, it has to be given priority over secondary evidence. So, many of the times it is practically impossible to produce primary evidence in the court of law because of their storage on hard disk, cloud, big servers and other electronic data storages. Hence, court has permitted secondary evidences. So, that secondary evidence can be taken to the court through printout on paper, copying or storing, or any magnetic or optical media produced by an electric device. So, now the evidences are primary, evidences are documentary and secondary, each and everything we have discussed. Now, the relevancy of evidence. The evidence is relevant or not. So, for documentary evidence in contrast to oral evidence, before placing reliance on the same, the court looks at the same evidence in the sequence of relevancy, admissibility and proof. So, generally, admissibility depends on relevancy. However, in the case of electronic records, which is also a document admissible as evidence after amendments to the Indian Evidence Act 1872, read with Section 2, subsection 1, subclause O and Section 2, subsection 1, subclause O of the Information and Technology Act 2000, admissibility precedes relevancy. So, Section 5 of the Evidence Act and the Section 136 of the Evidence Act say that relevancy must be established before admissibility. However, as per Section 65A and 65B of the Evidence Act, when read together, the said sections only deal with proof and admissibility of the electronic evidence and not the aspect of relevancy of such evidences. So, thus it is noticed that the relevancy of electronic evidence is determined only after determining the issue of admissibility of such evidence. That is, after submission of the certificate under Section 65B(4) of the Indian Evidence Act. Now, electronic data that can be considered as evidence. Which type of electronic data can be considered as an evidence? So, there are CCTV footage, your live locations, emails, social media messages, post, video, photos, audio, text messages, computer records, internet browser history, computer hard drives, electronic door access logs, ATM records, etc. So, these all are come under electronic data that can be considered as an evidence in any case. These electronic records are admissible if they are submitted in original. Suppose if I am asking about the audio and video clippings. So, if they are submitted in the original audio and video of anything, so this is valid and authentic source of electronic evidence and not the copied version. then this is the primary evidence. And this evidence does not need the certificate. So their copied version records on other similar or different device has to comply with the condition precedents under section 65B of the Indian Evidence Act and get the certificate for this admission in the court. So in the case of Tukaram S. Digole versus Manikrao Shivaji Kokate, it was observed by the Apex Court that new technologies are the requirement of today. So electronic evidence can be tampered because electronic evidence are actually fragile in nature. So there is no such detailed provision by which the admission of such electronic evidences may be assessed. So in this regard, relevancy and authenticity of these electronic evidences must be standardized and stricter than other evidences which are on document. So for this, the 4 steps can be used to make electronic evidence relevant, accurate, admissible in the court of law. So first of all, this step is identification. Identification of the evidence, because there are so many evidences are there in a computer system. Suppose a crime is committed by using an electronic device or computer system. So there are so many things. So this is the expert or the investigating officer who will decide or identify the evidence which is relevant, which can prove the crime. Second is storing. How to store the evidence? Because while storing the evidence can be changed or the form can be changed. Once the form is changed, the total scenario will be different. Third, analyzing. The expert will analyze these evidences, because sometimes these evidences which are identified and stored, they are not readable. So to analyze them is also a technical part. So the expert, they do this, and after that making it in the form that it can be produced before the court. So the court can understand it. So these are the 4 steps to just make electronic evidences relevant, accurate and admissible. Now the admissibility of electronic evidences in India, the second part of this session. So section 65A and 65B of the Indian Evidence Act 1872 tells us about the electronic evidences and admissibility procedure of it. These sections were inserted through the Indian Evidence Amendment Act 2000. The main objective of section 65A and 65B is to clarify the admissibility of the electronic record as evidence in the court of law. According to section 65A, the content of electronic records can be proved by the procedure given under section 65B. So first of all, we will discuss about section 65B. While section 65B tells us about the admissibility of electronic evidences in the court, subsection 1 of section 65B says that any information contained in an electronic record which is printed on a paper, stored, recorded or copied in optical or magnetic media produced by a computer shall be deemed to be also a document if the conditions mentioned in the sections are satisfied. And subsection 2 explains the conditions in which electronic records shall be considered as documents. So it is the same thing which I have told you earlier, that if any printed document, any printed paper is produced before the court as an evidence, it is called the electronic document, and it will be presented before, it can be presented before the court as an evidence. The condition is that these electronic records shall be considered as document and they will actually come under the purview of that records. Next, where a statement in evidence is sought to be given virtue of 65B, section 65B4 requires a certificate to be produced. So, if there is any statement, if there is any recording is presenting before the court in a CD or a camera or any other things. So, first of all, there is certificate is mandatory for that. Any camera clipping is there and any photograph is there, any recording in pen drive or CDs is there. So, the particular certificate is necessary for that. And section 65B4 requires a certificate to be produced that inter alia identifies the electronic record containing the statement and describes the manner which it is produced and gives particulars of the device involved in the production of the electronic record to show that the electronic record was produced by a computer. So there is a criteria, there is a format for that, how to produce a certificate before the court. So content of electronic evidence certificates are a statement identifying the electronic record, that this is the electronic record. Second, a statement describing how the electronic record was produced. Third, details of the device, that this is the device, this is its number, this is the make, and this is in the working condition, and it is recording day-to-day things. So we have to, the owner has to describe each and everything. A statement related to matter enumerated in section 65(2) of the Indian Evidence Act, that how it is a document, and a statement stating that the subject matter of certificate is the best of knowledge and belief of the person is stating it, that I am on the best of my knowledge that whatever I am producing on writing over here, this is true, and should be signed by a person having the official position of that device or management of that device. It means at the last, the person, the owner, or the officer in charge in which possession the device is, he will make his sign under the statement. So this is the content, these are the content of electronic evidence certificate. Now, who may produce electronic evidence certificate? So I said any of the one, like the owner and officer in charge, head of the department in which possession the particular electronic device is. So that person can produce the certificate. Now, retention of electronic record. It is mentioned under section 7 of IT Act, and it said the electronic record is retained in the format in which it was originally generated, sent or received. Means the originality and the authenticity of the evidence should not be hampered or disturbed. Third, stage of electronic evidence certificate. At which stage of the proceedings during the court the electronic evidence certificate can be produced. So it's at the time of trial or before the trial and before ending the trial, the particular certificate can be produced before the court. Content of electronic evidence certificate we have already discussed. Now, oral evidence as electronic evidence. So it is mentioned in section 59 of the Indian Evidence Act 1872. The contents of electronic records cannot be proved by oral evidence. But it must be noted that section 65B starts with the non-obstant clause. So oral evidence can be examined. If even after this a dispute arises, then report can be made to section 45A of Indian Evidence Act 1872 and 79A of Information Technology Act. So a combined reading of both the provision states that whenever a question as to the genuineness of the electronic record arises, it can be verified by an examiner of electronic evidence who is appointed by the central government. So the oral evidences, yes, it can be considered if they are supporting the electronic evidences along with the other evidences which is produced in the court of law. Some landmark judgment I would like to discuss here. First of all, State versus Navjot Sandhu, Afsan Guru 2005. So we also say this case or call this case Parliament attack case. So this is the case the Supreme Court had held that courts could admit the electronic records as secondary evidences without the authentication and certification for the same. This case was related to the admissibility of the record of telephone calls as e-evidences. So in this case, actually the accused stated that no relevant certificate could be produced before the honorable court were not relevant and not following the provision of section 65B4 of Indian Evidence Act. So the Supreme Court concluded that the call records were sufficient to admitted as e-evidence on the basis of the statement of the competent witness after the cross-examination which proved the function of computer during the relevant time. The second case, the second landmark judgment, where that was Anwar PV versus PK Bashir. In this case also, the decision of Navjot Sandhu case was overruled in this case and redefined the production of admissibility of e-evidences in the court of law and reinterpreted the sections 63, section 65 and section 65B of Indian Evidence Act. In this case, Mr. Anwar, after losing the assembly election in Kerala, filed an appeal and contended that Mr. P.K. Bashir, member of Legislative Assembly, had vanished his image by defamatory contents recorded in CD and form of songs. The Supreme Court denied accepting any evidence without the authentic certificate, because how it can be proved that the person has spreading the rumors. So it was held by the Apex Court that in the case of admissibility of any electronic evidence, the compliance of the provision of section 65B(4) must be followed strictly. And without this, the acceptance of secondary evidences as electronic records is inadmissible. The next case was Shafi Muhammad versus State of Himachal Pradesh. In this case, it was held that a party who does not have a device from which the document is produced cannot be required to provide a certificate under section 65B(4) of the Evidence Act. So the applicability of the requirement of certificate being precedential the procedural can be relaxed by court wherever interest of justice. This judgment was overruled by the court in the case of Arjun Pandit Rao Khotkar versus Kailash Kushan Rao Gorantyal and others. Finally, this confusion has been settled by a larger bench of Supreme Court in Arjun Pandit Rao Khotkar versus Kailash Rao Kushan Rao Gorantyal, where it was held that the procedure under section 65A and 65B is a code in itself and overrules the general provisions regarding admissibility of electronic evidences. This was the case, actually, the court had to adjudicating on an election petition which challenged the election of Mr. Arjun Pandit Rao Khotkar on the ground of the nomination papers were filed after the stipulated time. So the respondents wished to rely on video camera recording to prove that the candidate had filed his nomination after the time limit. The Election Commission produced CDs which contained a copy of the video camera recording in accordance with the direction given by the High Court. However, the necessary certificates were not produced before the court after giving so many reminders to the parties. During the cross-examination, an officer of the Election Commission testified that the video camera recordings are authentic. Based on this testimony, the High Court admitted the evidence of video recording, even though the certificate in accordance with section 65B(4) had not been produced. So the High Court held that it was satisfied that there was substantial compliances with section 65B, as a competent officer had testified that the video recording were authentic. After clarifying the scope of section 65B, the court upheld the decision of the High Court that even though it had relied on electronic evidence that was not certified under section 64B(4), this was because along with the electronic evidence, the High Court had also relied on other admissible evidence to conclude that the nomination papers were not filed within the stipulated deadline. So after this, after all these cases, the recent case, what it says that the certification under section 65B(4) is mandatory. But sometimes it depends upon the situation to situation and condition to condition, as we have seen the situation in this case also, that the particular officer in charge, he given the statement in the court that yes, this is the authentic evidence, and the other evidences were also supported this evidence. So in that scenario, the court accepted the evidence. So this is what the electronic evidence, admissibility of electronic evidences in the court of law. So I'm going to finish this session here now, and we will be back with some new topics. Thank you.